Welcome to the All Things Special About Education podcast. Welcome back. I am Shannon, the Executive Director of Kentucky IEP Advocate. I am here today with Nick Caprino. He is an attorney at the Children's Law Center in Northern Kentucky. Nick and I met 2 years ago.
That sounds about right. That's not too long after I started at Children's Law Center.
Yeah, probably. I reached out to any and every attorney I could find that might have the word education listed anywhere in anything that they were doing, and I put that effort together so that we could put together a legal advisory panel as part of our board of directors. So we're gathering attorneys together in a small committee meeting once a month for people who are doing this, people who are interested in doing this, people who have done this, maybe aren't doing it anymore, so we can kick around some ideas. I ask everybody for advice, I feel like, every single month. And so that's how Nick and I have known each other. But Nick, why don't you share a little about how you ended up at the Children's Law Center?
Yeah, I'd be happy to. I'm Nick. Thanks for having me and thanks for introducing me. I am an attorney at Children's Law Center. I've been there for about 2.5 years. I started off my legal career as a public defender in Kenton County, Kentucky. I did that for 8 years. I love doing that. But it was really hard work, really taxing work. I wanted to find a new place where I could still do service legal work. And one of my favorite parts of a public defender was early in my career when I got to represent kids. And there were kids who obviously they were going through really, really tough times, and it was very difficult, but really fulfilling to help those kids through that. So that's what led me to the Children's Law Center. The Children's Law Center is a unique legal services firm in Covington, Kentucky. We provide a variety of services to kids, really kind of do most anything that comes our way. But we mainly focus on representing children who are in need of education advocacy. We also represent kids who are victims of crime, victims of abuse, in custody cases, in criminal cases against their abusers in some cases, and also in protection orders. We also do some work in Cincinnati representing children who are facing homelessness. But within all of those, we do a lot more things for kids. Represent them in name changes, evictions, things like that. It's really our goal, and we always try to focus on making sure that kids are empowered to have a voice and to have some agency in what's going on in their lives. I noticed when I was a public defender, a lot of the adults I was working with didn't feel like they had agency. And I think if you can help children have agency in their early life, that can affect their outcomes in the future. And that's what I think is a good segue into advocating for educational rights for kids. So kind of one of the first things I always try to impart to the parents that I'm working with is the fact that they understand that they are just as important of a team member to the ARC team as anybody else there. And this is extremely important. Usually the feeling, and I'm sure a lot of parents can relate to this, you're going into an ARC meeting, you're worried that everybody knows more than you. You have experts that know more about the law or more about the rules that need to be followed or more about what the school has to offer. And you're just going in there and you don't know anything. And that's actually not the case. You're an equal team member as a parent, but you're probably the most important expert because you're the expert in your child. And that is, without having an expert in your own child, you cannot do anything successfully in the ARC meeting. So lean on that. Understand that you know the most important things about your child. You know how your child works. You know how your child doesn't work, what doesn't work for your child. And without that information, the ARC team really can't do anything. And it's important also to recognize there are other experts in the room that are experts at other things. There's a psychologist that's hopefully an expert in psychology, and you can lean on them. And that gets into a point I'll talk about a little bit later. never hesitate to ask questions. Everybody in there should be asking questions to you about your child. And you should be asking questions to everybody else about what their expertise is and why something should or shouldn't happen. So I'll talk a little bit more about how to ask questions. But first, I want to talk about preparation going into the meeting. This is another difficulty that I think parents maybe overthink a little bit. They think, I don't know what I need to talk about or what I'm supposed to talk about in the meeting because I don't know what the law is. Um, the the thing about the IEP laws are they're designed to, at least up to a certain point, they should be. The idea is that they're designed so that regular people can go in there and ask for what they need. Now, I'm not naive. I understand that that's not always the case, and sometimes schools may make it more difficult to understand than it needs to be, or may require a deeper understanding of the law than you would hope. But on a surface level, you should be able to navigate the very preliminary steps of getting into an ARC meeting and asking for what you want and taking even some steps after that. So the important part before you go into meeting, the most important part is be clear and identify what are your concerns, what are the issues, and be as specific as possible. A lot of times I am talking with parents and it's very clear something is going wrong. Something is wrong, something is bad. But the parent and think about this, if you're dealing with any problems in your everyday life that may not be related to your kids' education, sometimes in your head, you're thinking about it, this is a problem, this is bad, I know what's wrong. And then if someone asks you, can you articulate, tell me what the problem is? It's sometimes hard to get the words out. It's sometimes hard to say it specifically because it's just been boiling and reeling in your head. The same thing can happen with education. It's complicated, it's difficult, it's emotional. So I always encourage parents to take some time, think specifically, okay, things have been going wrong. Let's identify specifically, as specific as we can, what has been going wrong. Is it my child's grades? Is it my child's behavior? Is it how my child has been interacting with other students or interacting with other teachers? What specifically is the problem? Once you get this information clear and write it down, then you can start to hone down on, well, I think it's this particular issue that may be the problem. It's may not be the problem, but it's something you can at least say, okay, I have something clear that I think is an issue that I want help to solve, and the school should help you. So once you have those specific problems identified and written down in a list form, then think of some solutions. They may be something that you think the school would never do in a million years. Write it down anyway. They may be things that seem super obvious that you're like, obviously the school is already doing this, but I don't really know. Write it down anyway. Write down all the solutions you can think of. So then when you bring these into the meeting, you can be very clear about what the issues are and what the solutions are. The other part that I want to talk about is how or whether you should communicate, how much you should communicate what the issues are before you're going into an ARC meeting. And I guess I should probably distinguish whether you're going into an ARC meeting to start the process to get an evaluation for an IEP, or from the instance where you have an IEP and you want to make changes. I think if you are going into a meeting and you don't have an IEP yet and you're going to get an IEP, I think giving the school some type of outline of some of the issues that you're seeing is important. It's probably legally necessary as well to be able to overcome that threshold to get evaluations. So sharing that information with the school via email, and I'll talk specifically a little bit more about who to share that with later on. But sharing that information with the school beforehand is typically a good idea. When it comes to solving problems when you already have an IEP, I think identifying with the school on the surface, like, hey, I've been noticing this problem, that's fine. but actually trying to implement a new solution or change the IEP over email or just communicating that is not a good idea. You want to quickly say, here's a problem, let's do an ARC meeting. And then you can talk about the more specifics in there. So the kind of different ways to approach it depending on where you are in the process. And then once you get into that meeting, once you get in that meeting, you can talk specifically about what the issues are. All meetings are different, but most of the time, the coordinator, the chair of the art committee, is running a pretty strict schedule, and I can feel parents not really know, understandably, not really feel like they know when they can pipe up. So the easy answer is you can pipe up whenever. You don't have to wait till somebody calls on you, or you don't have to raise your hand. It can make it, you want to do it at an appropriate time where it makes it smooth and the notes can be taken properly. But understand that even though the meeting may be very structured, and this person may talk and this person may talk and this person may talk, you can talk at any point in time. It's a good idea not to interrupt people unless you don't understand something. I'm sorry, you mentioned that acronym, which we all know there's a million different acronyms that fly around, and I've been doing this for a little while, and there's still many acronyms I don't know what they mean. And I'm always sure to ask. I don't know what GHWY evaluation is. So it's important to understand that when you're in the meeting, you don't have to wait for your turn to talk. Sometimes if I don't want to say paint a broad picture of all school districts, but it is the fact that some school districts may avoid giving a parent an opportunity to talk, which is not okay. So you want to make sure that as the expert in your own child, you take that opportunity to speak out and talk about what your concerns are. And then once you get to a point where it feels appropriate, start talking about some potential solutions. When you're talking about those solutions, it is important to present all the solutions that you've thought of. Number one, it shows that you want to participate in this process. You want to help as much as you can. You can't be in there in the school teaching your kid, but you can give as many ideas as possible. Don't worry about the school saying no. That's fine. If the school says no, that's not a good solution, that's fine. That's not the end of the world. Now the next step is to ask why, right? Okay, why is that not a good solution? The optimistic answer is that, well, actually, the school has a better option that is actually more intense than the solution that you asked. The pessimistic, or probably the more cynical answer to that question is a school may say no to a solution, and you ask them why. And if the answer is that they know it's a good solution that could potentially fix the problem, but they just don't have the resources to fix it, then that kind of raises a red flag on their end, that maybe this is a solution we need to figure out how to fix. If they just say, no, that's not a feasible option, let's move on, you're losing the opportunity for the school to explain to you why that's not a good solution to solve the problem, as opposed to it's not a good solution because they just don't have the resources to do it. Them not having the resources to do it, although I'm sympathetic to that issue. I mean, a lot of us have experience. My family are educators, and I understand they're woefully under resourced. However, simply not having the resources is not an excuse for not being able to meet the requirements to educate your child.
I think
And go ahead.
one question in there is,
Mhm.
if not this, then what else? And it's
Yes.
not like just absolutely not. Being able to be like, okay, so why not? And then if not that, then what's comparable? What could we do that looks similar or gets us started or moves us in a direction? We can talk about this beforehand, but I'd like you to kind of touch on this thing that I'm sure I hear all the time from parents, that it's this whole like, well, that's not a bad idea. We need to collect some more data to see if that's what we should be doing. and then that we need to collect more data situation just keeps coming back and then keeps coming back and then keeps coming back.
Yeah.
So I try to encourage parents to be like, okay, how much, how long, how many data points, what are we looking for, what's the threshold, because this isn't going to be 9 months of collecting data, because that starts to feel like, to me, we're going to collect enough data that shows no, but if we haven't collected enough data to show no, then we're just going to keep collecting
Yeah.
rather than doing it. So those are kind of the two things I feel like. The no's are no, and I don't want to discuss it because we're under resourced,
Mhm.
or they don't feel comfortable saying that, so we get to this like collect data. Well, we need to watch this a little bit more. We're already here because we watched it, and that's why we're here, because we
Yes.
have the data that says this isn't working.
Yes. I think that's a great point. I'm a big believer in data, right? Like you don't want to make decisions without information. But like you said, it's extremely important to be very clear about what the expectations are if the school says, well, we can't do this yet till we have the data. Number one, um, it may be appropriate, it may not be appropriate, depending on what the issue is. It may be appropriate to say, well, let's just try this and gather data while we're trying it to see if it gets better or worse. That's not always appropriate, but depending on what the particular issue is, that may work. But it may be an issue that the school, because it's maybe an intensive solution, they don't want to implement it because it may be resource intensive, or it may impact the child's development in with an unintended consequence, and they want to make sure that that's not happening. In that case, you probably do want to have some data. So I say, if that happens, that's fine. Say, set a deadline, and I think it's perfectly fine to set a deadline. Sometimes when you're working collaboratively, there is a give and take, right? You have to listen, you have to be open minded, and you have to listen to the school. One area where it feels really easy to give and give into collaboration, where I actually think it's a detriment, is timelines and deadlines. I've learned over time, and I used to give in earlier in my career when I was doing this on timelines, to think like, oh yeah, it's fine if we kick this out another week, like we'll give you some more time. That snowballs, and I think the time requirements that are required under IDEA are very good to stick to. Especially the 60-day evaluation. I've been in situations where it's just taken longer, and I thought it was a good idea to be like, yeah, we're not going to throw a fit if it takes an extra week, and then something else comes up, and then something else comes up, and now you're in a bad position where you've given time, and there's really no solution. So I think one area that you want to always be very firm is deadlines. The deadlines that are required by law, but also deadlines that you set. You can say, I think this is a good solution. That's my hypothesis. I think implementing this particular check-in, check-out procedure for my child will help their behavior issues. That's my hypothesis. If you want to collect some more data before we do that, that's fine. I would like to see that data within 2 weeks, and then let's make a decision together if we're going to do that, if we're going to implement this or not.
Yeah.
It will be the school may not like it, but when you set it out like that, it would be very difficult for the school to say no, or at the very least to say like 2 weeks is a little ambitious, give us 3, because that will give us, XYZ. Okay, that's fine. At least we have a time that says this is going to happen. And you can even set the next date for the next ARC meeting if that's the way you want to handle it. So I think that's a really good point. Is and now that you say that, I do hear that a lot from parents before they talk to me, that they have been told again and again, we're looking at the issue, we're seeing what's going on. It really doesn't even get to data points. It's just like we're trying to figure it out, and there's no deadline. Um,
Another thing I hear as you were talking, another thing I hear, if it's not the data collection, the pushback can sometimes be, we're not really sure if that would work. There's this perception of, we can't implement something unless we already know it's going to be successful. Well, so then collecting data is really important to know if it's effective. Using evidence-based practice as an OT, I'm out here, practicing with evidence-based practice. We're doing the things that work. Sometimes evidence is research articles. Sometimes that evidence is I see this happening with my own eyeballs in front of me, and we're going to keep doing the thing that works because I have evidence that says this works. But sitting in as a group and saying we're not really sure how to address this and we don't know if that's going to work, we don't know if that's the solution. So then it almost becomes a conversation of like, why are we not trying this then?
Yeah.
It feels like there's pushback when there's not a guarantee success. And I think that goes like one thing that we talk about as a committee all the time is collaborative advocacy, making sure that, you know, you're not going in trying to stir things up and you have a good relationship. And with that collaborative advocacy, it's like, I'm not expecting you to solve this problem immediately with what I'm asking you to do or the solution that I'm offering. But I think it's a really good starting point, and we can circle back together in 3 months and see if this thing is working. And if it's not working, if there's no progress, if it's off the rails, it's not anybody's fault. We just need to do the next thing.
Exactly. Yeah. Sometimes the data is already there. We have the progress reports that show this is not improving. So yes, we don't have 100% certainty that my suggested solution is going to work, but we can gather data and get more certainty on whether it works or not. And if that doesn't work, then we'll try the next thing.
Yeah.
That's a really good point.
It feels like sometimes school districts are hung up on the need to show progress, that it's like, unless we are 100% confident that this is going to be able to show progress, then like we don't want to do it. But then that also just feels like it's at a standstill because we don't know what's going to make progress, so then nobody does anything.
Yes. Yes. Really good point. Really good point. Um, so, that's kind of the bulk of what I wanted to talk about in the meeting, making sure that parents are empowered to be able to advocate for themselves. And I don't want to discourage having an attorney in those meetings, because I think it's a great thing if you do have someone to advocate for you or an attorney. It doesn't have to be adversarial, even if you bring an advocate or an attorney. But um, number one, not almost all parents don't have the resources to do that. And you should be able to advocate for your own child in most situations. There are some situations that just get out of hand and they need to go to litigation. And I completely understand that. But I want to make sure that parents are given the tools to be able to advocate for their child and understand that you don't have to have an attorney in most cases. I want to talk briefly about record keeping as it pertains to communicating outside of the meeting about what's going on. That's something that has to happen. So as a lawyer, you always want to make sure things are on the record. When I'm in court, I want to make sure something is on the record. Judges will say, if it's not on the record, it doesn't exist. So it doesn't matter what you say if it's not on the record. When you're in an ARC meeting, the record is the conference summary report. But to be able to get the meeting going, to be able to talk about issues and be able to present the problems that you're facing, whether it's getting an IEP to begin with or changing an IEP that you have, you do have to talk about some stuff outside of the meeting. So the simplest thing I can say is make sure everything is in writing at some point in time. What I often hear about that is disheartening is that parents send an email to the school and about problems. They do not get an email response, and they get a phone call from the school that talks about some of the problems and gives some of the answers that we've already talked about, like, we're going to figure this out, we're getting more information, we're going to do this stuff, don't worry about it, give us a couple weeks and we'll have a solution. Hang up phone call, there's nothing else in writing. The only thing in writing is the email you sent with no response. That's not going to be a sufficient record. Emails, if a case does get bad, and if it gets contentious and gets to litigation, emails can be made part of the record, but there needs to be some back and forth. There needs to be some recognition. I'm not saying don't do phone calls. You don't have to tell the school. Sometimes phone calls can be much better to work out problems than an email, but you always want to follow up and memorialize phone calls with an email summarizing what was said on the phone call. So if you are in that situation where you send an email, you don't get an email response, and someone from the administration calls you back, say, hey, tell them at the end of the phone call, hey, I'm going to send you an email that kind of summarizes what we talked about. Feel free to make any changes if anything I say isn't accurate based on what we discussed, but I'm going to send that email. And that puts the school on notice that you're taking this seriously, you're holding them accountable, and that anything, what they say, is going to be in the record one way or another. And then make sure when you're sending emails, send them to more than one person. I typically tell parents to send them to, you want to have somebody in the administration, can be a principal, doesn't have to be someone with the district, but it can be someone with the district special ed department. um I'm talking in addition to the school special ed department. I think you want someone from the district special ed department, someone, a special ed teacher if they're involved with the particular school, and then someone else that you trust. It may be one of those people are already listed, but there may be someone else, a general ed teacher that works closely with your child that you just trust to be able to make sure that things aren't being miscommunicated. And then when you send emails, make sure all of those people are CC'd on the emails. Hopefully, all of those people are part of the ARC team. If they're not, you can request that they be part of the ARC team as one of the required members. It can be helpful to have those members in there. And again, just make sure that everything you talk about, it's not something that has to be adversarial, saying like I need this in writing or it doesn't exist, but it's something you want to do to protect yourself and to protect your child, in the future, not just if there is litigation in the future, but also too if you get into an ARC meeting where things start or said that you don't remember really being part of the conversation before, you can go back to something that you have in writing and say, well, when we talked about this in the email, you said this. Please explain to me why it's different now. So yeah, I think that's an extremely, that's something lawyerly that any person without a law degree can do, and I think it can be, think it can be a big help.
Yeah, for sure. One thing I want to wrap this conversation up with is confirming, having a little discussion about how, that's something that parents, it feels better to have somebody with knowledge sitting with you. So that's, parents ask me to come to a meeting. I don't have a schedule usually that even allows for that. And in general, if a district doesn't have somebody comparable to me, then and they struggle figuring out who to invite, because if they invite you as an attorney, they're going to invite their attorney. So, that there's nobody comparable really to me in a lot of ways. And if I don't know the student, I'm not really bringing much to the table since I'm not an attorney and I don't know you through like a therapeutic relationship to know what to be recommending. Um, but while that does feel better, if having somebody with you feels better, then bring somebody with you. Just bring somebody. Talk about that trusted person.
Exactly.
Bring your neighbor, your mom, your sister, your best friend, your husband, your wife, your who knows,
Yeah.
whoever.
Maybe
And
someone that is, if you maybe kind of don't like stepping on toes. Some people just have that kind of personality. I have that sometimes. um Bring somebody that is a good friend but also okay with stepping on toes and okay with asking questions. I Think about it, going to a doctor's appointment, and you have something that you're looking into. A lot of people will bring somebody that will think of questions to ask that they may not have thought of.
yeah, and
Yes.
maybe having that firsthand knowledge about them.
Yes. Think about, so parents are worried about everything they don't know when they go into those meetings. Well, we're here to talk about your child. I can guarantee there's an administrator in that meeting that has never met your child before and has no idea about your child. That's not a good or bad thing. They need to be in there. But it shows you that they don't know anything about the main subject of this meeting, the most important subject of this meeting, and you do. So yeah, not everybody's an expert in everything, but you're an expert in the most important thing in those ARC meetings.
Absolutely. All right. Thanks. And we are going to get back together for a second conversation about the conference summary report, which is the record, since we've been talking about records and keeping things in the record, that is the record of the ARC meeting. So it is important that it is accurate, and I want to make sure we give it some good time. I'm going to include the Children's Law Center website and Nick's email address in the show notes below, wherever you're looking at this or wherever you're listening to this. So if you need to get in touch with him or the Children's Law Center, that is both available, and we will circle